171218-FA.
Right over this.
Going Honor, I hivatkácsot representing Denzel Robinson.
This is the candidate hearing, however, tonight change having new potential probation as well, is that right?
Yes, Your Honor. The new probation valuation it's a new charge in this court from St. Clair Shores. And Your Honor, my client decided to plead guilty to probation valuations of both warrants. However, we request adjourning sentencing that he will be sentenced together with them.
Well, we're expecting the home evasions to be, if they are bound over, they will be bound over to this court, correct?
Yes,
we want to just wait for those to be bound over then?
He's already bound over. The next hearing arraignment on information is on June 11th.
All right, then we'll set this hearing for that date then?
We may do it.
All right, that's what we'll do then. We'll adjourn until that. But in regard to the new arraignment, I'm assuming that it's waiting formal arraignment, is that right?
Yes.
And pleading not guilty or standing new?
For these purposes, yes, Your Honor.
All right, of course, got Aaron not guilty plea on your cat. I think because of the last date, he must have had a lower bound, if I'm not mistaken.
Let me check that for you.
What was on there, this new charge?
So he was arraigned on the first warrant, we gave him a 10,000 cash rate, 10%. So I don't show.
All right, what I'm going to do is make the 20,000 cash charge in light of these new allegations, and we'll set it for the same date as he is up for an arraignment, not before this court. Okay?
Yes.
June 11th at 1:30.
Yes.
All right, thank you.
I think he been working here.
Yeah.
No, it's
I've been in Canaan for 14 years now. This one here, I told him 6 years. 6 years. I actually told him from C-section.
Yeah.
Did you ever see him?
He's the bloodhound, right?
Yeah. You know, I think I saw a different.
Yeah, I had red shepherd. Yeah, my shepherd was put down last year. And 13 years. Yeah, they could have been tracked if we backed up in the woods and all.
There's a whole mess going on downstairs right now. So. That's right. That's right.
No.
Yeah, you use them a lot, right?
Just tonight.
I work in this.
Can we have Harold Ellison downstairs? Okay.
Four different directions. One of them was almost 3 miles. But they were pretty impressive. Maybe this day we told everybody.
They hold them themselves. That's a lot.
Oh, it's not, we're not here today.
You don't even need to push the buzzer with that door. And then he pushes the buzzer. It's usually the door.
Yeah, like, yeah, that should be out.
Kind of case you have there. Sometimes they're interesting cases. Sometimes. I've been in my share of them.
Yes, same here. Lots of stories. Are you, so you with this for the trial?
And the extra
The
security.
extra security, okay.
Yeah, our whole, our whole midnight shift got overloaded. The whole shift.
So,
We got 7 inmates in the hospital. And it's the most silliest thing I've ever seen. The other day I got ordered to watch some person in the hospital that's got a $1,000 10%. So they're giving out personal bond. I never understood this. So the personal bond, the county picks up the tab for bypass, surgery. It's like probably $40,000 to $50,000. And the county's not paying.
look at that.
You know, it's like,
10% of the 100 pounds.
here, I can be able to look at my taxes won't go up. It's crazy. It's the most silliest thing I've ever seen. In the fall time, you'll get the, tournaments goes in all one, so everything gets paid. They'll go to the restaurants or whatever, get a meal. Nah, not really. From me, that's a Mexican here, so.
Some of the world that I don't know much about.
Yeah, I think about that. I was so, I want to write books so bad. I wouldn't shop for 24 years. You know, it's just like, I don't know why you want to call it criminal justice. I got a lot of trials. People billing them. It is so true. Order from the attorney. It's more like it's a drug right. You got to order from the attorney. Or if you got your paid attorney, it's totally two different outcomes. You know, I've seen it done time over time. You know, like the court attorney, the guy get jail time, and the guy that's a paid attorney usually walks away with it. I'm like, how's this fair? You know? And you see it all the time in your step courts and stuff. I just shake my head at it. It's good to get this job. Well, I was on I just despite doing drivers and like I almost got killed by one last. I was one that got hit at 29 and they make that off. Like my driver, my dog got it, and I got 2 broken ribs. You know, I was sent to the Florida hospital. Of course, she said she said she had a green light. It's all on my video. She ran right through the red light. You know, my team. But she went through the red light. You know. So we're still doing it. That was August 26th of last year. We're still doing it. So we're actually here in Diane's
The state should have been back over by now, but
yeah.
craziness.
Well, they just kept postponing and she fired 4 attorneys. So it just kept postponing. So now finally it's getting, this has got a court date set. Trial date. I just found out that 2 weeks ago I gotta have surgery, kind of that, my shoulder. They tried rehab and this electrical shock in my shoulder. I've been doing it for 5 months now, and it's just not working. So I finally went back and got an MRI. And yeah, a surgery. I'm trying to pull on it as far as I can go, because I hate the fall of life.
And the recovery.
Right?
Then you have to do therapy after that, just for surgery.
Well, I didn't retire when I told him. And I told him I really was going to do the surgery till I got retired. I really thought.
If you could wait.
Well, right now, I couldn't move my hands on my knees.
All right, common case is called Pickle versus Antonio Woods, case number 18-010-662-664-665.
Seated on 90 people.
Good morning, Judge. Jeff Kojic for Mr. Woods.
All right, this is a 10-case separate sentencing. This court is ready to receive a copy of the pre-sentence investigative report.
Yes, Your Honor.
Any additions, deletions, or corrections?
Not to the report, we just have a couple of issues with regard to the guidelines this morning.
Okay.
One is improperly scored. Just so the court knows, when we were here before, we scored it at 81 to 135. Probation has it at 126 to 210.
Well, just a reminder, please make sure your cell phones are turned off. Thank you.
I think the proper scoring, depending upon the ruling, may be 108 to 180, and I'll explain why. First of all, PRV 6, we originally scored at 0. It should properly add 5 points because I was not aware of a pending misdemeanor warrant for my client in Harper Woods. That would increase the level to a D, score him at 25, so I agree with that score. The next one is OV, I'll go to the one I don't think is in dispute, OV 10 regarding predatory conduct. Probation scored 15 in that file, and I would respectfully disagree with that scoring. I just don't
I think we're in agreement on that, Judge.
Okay.
All right, probation, anything, any response? I'm not sure why it would be predatory conduct.
I believe the author of the report believed that the defendant and co-defendant were seeking out certain types of people, seeking out the store clerk, being alone in the store at the time, and considered that pre-offense conduct directed at the victim for the primary purpose of victimization.
All right, I don't believe that's appropriate, so I'm going to score that 0.
And then the one I believe that's in dispute is OV4, which I would ask the court to score at 0. It deals with psychological injury to a victim. I acknowledge there was a statement in here from one of the victims that he felt paranoid and he's looking around when he works, things of that nature. There was nothing else of any note about psychological injury or impact to any of the other 4 victims. There's a couple cases. One that just came out in December, People versus White, a Michigan Supreme Court case that dealt with an armed robbery, and it dealt with someone putting a gun actually to someone's head and robbing a store and so forth. And there the trial court scored 10 points, just saying inherently someone would have psychological injury in going through such an experience. The Supreme Court actually remanded to have that scored at 0 and resentenced because the court said there needed to be some manifestation of actual psychological injury, some actual evidence and so forth, which I don't think we have here. I know the one young man talked about being paranoid and so forth, but there's been no treatment. And I know treatment is not required, but to me, anyone who's victimized in a crime, has fear, has trepidation, things of that nature, and I don't think that is swallowed up under OV4 to score 10 points. Otherwise, in all honesty, most crimes, or almost every crime, it would be scored no matter what.
Yes, Judge. In that White case, one of the reasons they said they didn't score the 10 points is because the judge and the prosecutor had just assumed that there might be some injury, some psychological injury. Here we actually have a victim's impact statement in the pre-sentence report that states what his fear was, how he is paranoid, family, how he lives his life now. And according to, there's a lot of case law about OB4 and how you document that. People versus Gregory, 2018, Mishat, Lexus 2335, People versus Mulholland, People versus Murdoch. All of these cases, they emphasize OB4 and how there has to be something aside from an assumption in order to score those points. And here we do have something that's aside from an assumption. So I'm asking the court to score those points.
Which is paranoia?
Yes.
Which is
Fear since the robbery. The fact that, he says that his trustworthiness was questioned. He said he has not attended counseling, but he did talk about the effects of the robbery, and that's more than just assumptions.
Judge, I guess I'd respond that anyone's going to have an effect from being a victim of a crime, a robbery, an assault, things of that nature. I don't think that it necessarily mandates a score in OB4 to score 10 points. I think we need more than someone saying, I have fearful or I had paranoia because of what I endured, things of that nature.
Do we have the
No, I don't believe he's here. Shelby Risky in the audience at all? No.
Well, there is a requirement that the court thinks it's clear that there's psychological injury. The question is whether it's serious psychological injury. That's really fine to demonstrate. And I understand there's something there, but is it enough for serious psychological injury to establish by a preponderance that it is in fact serious? The court doesn't believe that that's enough. There could have been more questioning over the complainant as far as how serious he believes, whether he believes treatment would be appropriate, etc. That just wasn't done, and that's by omission more than anything. So at this point, the court is not convinced that officer because there just isn't enough there for the court. If the complainant were here, of course, he would have an opportunity to speak to address the court on that factor, but he is not here, so I'm not sure if any sentence it's going to be screwed at 0.
Thank you, Judge.
All right, anything else?
Yes, the guidelines now therefore 108 to 180. This is an unusual case in many respects. From a punitive standpoint, it's unusual that we're dealing with armed robberies, capital offenses, and 5 of them, really back to back to back over multiple days. It's even more unusual that this gentleman, other than this larceny misdemeanor warrant, has never been involved in the criminal justice system as an adult. He's not been in trouble. He's pursued his education. He's got wonderful family who make up the whole front row, I believe, of this courtroom. His mom, who I've met with on a couple of different occasions, is truly a unique individual, tried to raise him properly and guide him in the right path. She works 2 or 3 jobs, doing everything she can. When I asked him why he did this, we always see on TV, unintelligent criminals, things of that nature. That's really the epitome of what was going on here. His childhood friend had a young child, a baby, living in a car in his driveway. It was Christmas time, she wanted to have some stuff for kids, and they made the collective choice to go use a fake gun and rob multiple 7-Elevens. They got caught, and then they freely admitted to multiple others, really with not a lot of investigation. They volunteered all the information, so it's just mind-boggling. He is intelligent, he is well-spoken, he is remorseful, he is sorry. He knows he's changed his life forever, and he's changed everybody in that front row's life forever. I think he will learn from this. I think that he will grow from this. I think he will pursue whatever options are available to him in the prison system to train himself, to educate himself, so on and so forth, to get away from marijuana. He's not an addict. He wasn't robbing to go feed an opiate addiction or things of that nature. He did it to buy presents for his kids at Christmas, and it's just a ridiculous decision, which he accepts responsibility for. I would ask the court to consider the bottom or even a year or 2 below the guidelines to see him get out hopefully before his 30th birthday. I know that Antonio would like to briefly address the court, and he's very remorseful for this to every single person that he put in fear on those 5 separate occasions.
Your Honor, I would first off like to extend my apologies to all the victims that were affected by my selfish behavior. I would furthermore like to offer my apologies to the family of my co-defendant as well as my own loved ones. I pray that the court will consider the fact that I'm truly not a very bad person just more so a young man who was just suffering from depression, negative influence, and greed. Since my incarceration, I have time to reflect on my wrongdoings, and therefore I hope that the court will perhaps show me some leniency into your judgment. Thank you for your consideration.
Just to note, Your Honor, the restitution, as indicated on each of the dockets, does not note that it's payable to 7-Eleven stores. That addition.
Yeah, Judge, I just want to clarify the fact that this was incidents that occurred, 5 incidents over 3 jurisdictions over a period of 10 days. And some of them occurred before Christmas, but at least 2 of them occurred after Christmas. The defendant also indicated in his statement to police, in his confession, that this was a thrill for him. And I want the court to take that into account in considering the sentence, because getting presents and getting some money for Christmas, could have been accomplished before Christmas in 3 robberies. It didn't have to go here. And the defendant continuing to rob places and indicating that it was a thrill for him, takes that narrative and essentially destroys it.
All right, is there any answer that
No, Judge.
anyone?
No.
All right, the policy of the state of Michigan here is individual sentence you wherever you may be sentenced to better particular circumstances as well. Sir, if this were one robbery, perhaps there would be a reason to go below the guidelines. This isn't this is 10 robberies, and I should say 5 robberies, it's 10 days. It's pretty incredible what you have engaged in, and I recognize what you said, what your attorney said, that it seems that you completed high school, you have no prior criminal convictions at all in your history, nothing, no misdemeanor, no other felony, and then you go off and do this. And I have no doubt that some of that is due to desperation, due to holidays. The prosecutor makes a good point that at least 2 of these occasions occurred after the holidays, and you seem to have had some sort of thrill for doing this. And the court also has to take that into account. I can only imagine what the victims, what you had put the victims through. Remember, this was their holidays too, and they had experienced the holidays with sort of the backdrop of having just been robbed and having a gun. But I do think that the guidelines are appropriate and support. I think they're indicative of what we should receive. I kept it. I don't have the guidelines. I'm going to stay within those parameters. Sentence you to 120 months to 240 months with credit for 147 days served. This is on file number 18-0410 FC. You're to pay restitution. Is it restitution of $711?
Yes.
Restitution of $200 to 711, $136 taken for cost, unvictimized assessment of $130 for cost of $200 and attorney fees in the amount of.
Judge, in that file would be 0, because I can only go for 3 to 5 files, so that file would be 0.
File number 18-0662-FC, again, 120 months to 240 months with credit for 147 days served, restitution amount of $200 to 711, $136 taken for cost, unvictimized assessment of $130 for cost of $100, attorney fees in the amount of
800 on it, Judge.
800.
I billed 12.8 extra hours at $25 an hour their rate, but they apparently did not approve that. So I billed 1,400 on that file.
Okay, I
All
know
right,
that.
so that will be ordered on file number 18-0663-FC, 120 months to 240 months with credit for 147 days served, restitution of $400 to 711, $136 to work cost, crime victimized assessment of $140 for cost of $100, and attorney fees.
was $537.50 for that.
File number 8, that's order 18-0664-C, 120 months, 240 AOC, 147 to serve, restitution of $100,
Come on.
$136 profile, contract amendments assessment, $130 profile, $100,
Come on, come on.
$268.75.
So ordered, file number 18-0665, 120 months, 240, federal, 127 to serve, restitution of $200 to someone else, $136
Zero.
So you're still going to be a young man. That's not get out. And I hope that you can learn because your family's going to start but I wish you the best of luck.
All right, Woods, it's your appeal. That's what I was talking about. Come on, this is important. You can get this.
You are entitled as a matter of constitutional right to file an application for leave to appeal your conviction and sentence if your financial equity afforded in the world and counsel resident thus for assistance by the finance committee. Classification now proceeds upon the sign.
He signed it, Judge.
He did receive the judge's sign. Thank you. Good morning.
On the case of People versus Robert McRae, case number 18-1105.
Good morning, Your Honor. Matthew Kolodziejski on behalf of Robert McRae, who is approaching the date and time set for sentencing. Mr. McRae and I have reviewed the pre-sentence investigation report together. I have one correction, Judge, relating to his employment. He recently obtained a new job at the Shell gas station in Lenox, Michigan, and that is apparently going to be a full-time position.
That'll be noted. Anything else in terms of additional stations for
No, Judge, nothing else. I do agree that the guidelines are correctly scored at 0 to 3 months. By way of allocution, Mr. McRae is 21 years old. He has absolutely no prior criminal record. I think the report really speaks for itself. The recommendation is more than fair. I think he's entitled to an opportunity to keep this off of his record and complete a term of probation. So we'd ask you to adopt the recommendation.
All right, sir. Anything you want to say?
I want to apologize for my wrongdoings and just want to make it right.
All right. Anything from probation?
Nothing to add.
Anything from people?
No, Judge.
It's the policy to say that should be received by sentencing currently. The sentence must be higher, but the case as well as the defendant. I'm going to base you on. What was it that you were using again with the substance? It was toxic, right?
It was,
No, it was Klon.
that's right, Judge. There was, I think, a single pill found in the vehicle.
All right, what I'm going to do is, you're going to be on probation in 9 months, pursuant to section 7411. You're not to use any drugs or alcohol. You're submitted to drug and alcohol testing. You're to take a psychological evaluation when you're feel attention. Waive confidentiality and allow a treatment program that you're required to attempt to disclose information to your field agent, not engage in assault, abuse, threatening, or intimidating court costs is $600, attorney fees is $600. I'm not doing anything for you. One, I think that's not hard. If you're moving to Florida, I don't know what their laws are. I'm allowing him to move. He can visit Florida to establish residency there and attempt to report with the Interstate Compact Act. So I'm going to allow him to travel, but he can't live there until there is this authorization from Florida as far as the Interstate Compact Act. Account number 3 is $50 state court cost, $100 fine, no probation. You're entitled, you must maintain probation before any supervision during the pendency of any probation violation issued. Please prepare content criticism law for one sworn to a probation officer. Your assessments must be paid in full 56 days prior to discharge. You are entitled as a matter of constitutional right on the application of legal conviction sentence if your financial attorney is the coordinate attorney or open counsel to represent you under the persistence of the strength to be made within 42 days. Funds now being which may have a trust please now proceed with on my sentence.
Acknowledge your seat, Judge. Thank you.
Attorney fees actually keep us at 75, Judge.
All right, so
And it's 7411 in count 1?
yes, 7411.
Thank you, Your Honor.
Well, he's in second floor. Can we do murder? Is he up already?
No, he went to go get him, so
Yes.
you want to do King first?
Please.
Okay.
Marcus. Marcus, to my left.
Current case of people versus Marcus King, case of subject of
Yeah, Ron Marsh on his behalf. It's a probation violation. Hearing is not necessary. He acknowledges that he violated probation in that he was prosecuted out of Warren on the offense of domestic violence and interference with a police call. That charge was dismissed, but he did plead guilty to domestic violence, and he has been sentenced to a 1-year probationary sentence with 769.4A application. But nevertheless, he's going to plead guilty to probation violation based on that content.
All right, so if you raise your right hand, do you swear or affirm the testimony that you will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, put your hand out. Please state your full name for the record, please.
Marcus P. King, Jr.
And Mr. King, do you understand that if you're found to have violated your probation, you can face up to a maximum penalty of 10 years of continuation department corrections for the underlying charge of possession of methamphetamine?
Yes.
You have the right to a hearing and contest the charges. You understand that by pleading guilty, you're waiving the right to that hearing, and you're also waiving the right to an attorney to represent you during that hearing.
Yes.
Aside from what we have said in the court today, is anyone promised you anything if you plead guilty?
No.
Does anyone threaten you if you plead guilty?
No.
Is it your own free choice to plead guilty to this charge?
Yes.
Are you pleading guilty because you're in fact guilty?
Yes.
Tell the court what it is that you're done violating.
Well, were you, first of all, were you convicted, did you plead guilty to the offense of domestic violence in the city of Warren?
Yes.
And was that based on you having assaulted your significant other, Wanda?
Yes.
Wanda?
Yes.
All right, probably the plea made is not voluntary and understanding. Of course, I was satisfied that the factual basis has been made to establish a probation violation. Mr. Mark, anything that you're saying?
Judge, I certainly don't want to downplay this, but in general, apples and oranges, that case from this case, and Judge Suzanne Pons has allowed him to return to the home. The complaining witness in that case, Wanda, actually called me yesterday, confirmed 9 o'clock today. Judge Pons lifted the no assault of contact, so they're back together. And as I said, he's on 7694A status. I handled the sentencing. I've shown the order of probation from Judge Suzanne Pons. So we're asking the court to please continue the 7411 application on the possession of ecstasy. He's employed with Chrysler, and that's about all I have to say.
All right, sir, anything you want to say?
I just want to apologize to the court once again, and I definitely do take responsibility for my actions.
Anything from probation?
Just to note, Your Honor, although our recommendation was made prior to his sentence in the district court, it appears that they have done just what we've recommended. They put him on 90 days sober length and it required his attendance at a 26-week ADA program. So he
Okay.
has been ordered to do those conditions as we were recommending as well.
All right, you know, I mean, the thing that I need to do is just continue on probation without any sort of sanction from this court. I don't know if that's appropriate. I understand that you were sanctioned in this other court, but, and Mr. Marsh, I appreciate you saying that this is apples and oranges, but at the same time, I don't know if substance abuse was stemmed from this behavior. Listen, I'm gonna give you a choice. I'll give you, I'm gonna give you 14 days for home county jail for sanction, or I'll just terminate your probation right now without that, section 7. What do you want to do?
Can I have a minute to talk to my
Yeah, absolutely.
Can you judge with the court allow him to do weekends?
Yeah.
No big keep My client just indicated he'd like to take continued probation.
All right, this is what we're gonna do then.
And you're going to succeed at
I don't know
probation,
how that's
correct?
gonna affect his grant, though. I'm gonna have to take that off every time he comes into.
Well, he's not, the Sober Link, I think, works a little differently. Maybe the defendant can clear up how the Sober Link works.
Is that through house arrest services?
Yes.
And that's something you blow into 4 times a day, correct?
Yes.
And so,
So it's
Judge,
not actually on.
I think he can show,
That's what we'll do. That's what we'll do. We'll do 21 days, same. Does he have any credit?
He has only 1 day.
We're just gonna do the 20 days sanction. How many weekends is that? Maybe we'll just talk in terms of.
Pretty sure you get to 20.
3, so that's 7 weekends.
Yes.
Yeah. 7 weekends, and we're gonna start this weekend. You have to report on Friday at 6 o'clock. You always have to report on Fridays at 6 o'clock for the next 7 weekends. You have to show up with a photo ID. If you don't show up with a photo ID, they're gonna refuse you. If you show up a minute late, say we'll refuse, and then it will give a probation violation, and then I'll bring it back here. So make sure that you show up at Friday before 6 o'clock p.m. With a photo ID, and probation will be continued with the benefits section 7411. You're entitled as a matter of constitutional right following application for each related conviction and sentence. If you're financially unable to afford an attorney, the court will appoint counsel for rest. So your appeal rights, okay. Plus persistence of an attorney is to be made within 42 days of payments now to be handed to which you made at request. Please do not receive a form by signing and signing the letter of receipt.
He signed it, Judge.
This is your copy here, okay?
Judge,
Hang on, that's your appeal rights, okay?
Four weekends.
great. Can he, do you work Mondays? Can he,
I don't think they take minutes.
Yeah, Mr. Marsh, I'm not trying to be difficult. I think they have it set up the weekends Friday.
okay.
So,
Are you going to have to get a few days off from work? All right. And on his behalf, thank you, Judge.
Thank you, Judge.
Wait for me in the hallway, please.
Just make sure you.
I just need that be signed. I can tell you. Harold? Harold? Now, here's the advice of rights form that I would have read to you. Sign your name right there. And then you're not going to be graded for legibility, so here, to sign that one too. Right there where the X is.
This is not a second drug case. Remember here? Here's our
Calling cases of Mrs. Harold Paulson, case numbers 2017-271-FA, 2018, 1236, 1237, 1238, FA.
See the mic, people.
Yes, and Ron Marsh on behalf of the defendant. He's been advised of all of his rights on all 3 of these files. He's prepared to plead guilty to all charges in all 3 files, and inherent in these pleas is tacit acknowledgement of probation. probation violation also.
As well as an official for
Yeah,
all cases.
thank you.
All right, sir, can you raise your right hand? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you can raise your hand now. Please state your full name for the record, please.
Harold Ellison.
And Mr. Allison, are you a citizen of the United States?
Yes, sir.
Are you currently taking any medication?
Fusion medicine. Relax.
All right, does that medication affect your ability to fully understand and appreciate the nature of these proceedings?
No, sir.
All right, so you're having no difficulty following, is that right?
No, sir.
Are you under the influence of any drugs or alcohol?
No, sir.
It's my understanding that you're going to be pleading guilty to 3 counts of delivery, manufacturing less than 50 grams of controlled substance, all individuals are noticed. They are all punishable by up to life in the National Department of Corrections. Is that your full understanding of this predisposition?
Yes, sir.
You understand that you decide not to, you are on probation to this court, are you on probation for all anywhere else?
Misdemeanor probation and for traffic tickets in Detroit.
All right, you understand that your plea of guilt may cause a violation of your probation, may cause a violation of your probation, or affect your supervision in both jurisdictions, you understand that?
Yes, sir.
You understand, if you decide not to allow yourself all this plea disposition, you to be entitled to a trial and entitled to an attorney to represent you from start to finish, including trial, sentence, and appeal.
Yes, sir.
You understand that by accepting your plea, you will not have a trial of any kind.
Yes, sir.
You understand that by pleading guilty, you waive your right to trial by jury.
Yes, sir.
You understand that by pleading guilty, you waive your right to trial by the court in both prosecuting judges to agree.
Yes, sir.
You understand that by pleading guilty, you waive your right to have the appearance and confrontation of all witnesses against you at trial.
Yes, sir.
You understand that by pleading guilty, you'd be waiving your right to call witnesses and present evidence in your defense at trial.
Yes, sir.
You understand that by pleading guilty, you'd be waiving your right to have the court order witnesses to appear and testify at your trial.
Yes, sir.
You understand that by pleading guilty, you'd be waiving your right to take the witness stand and testify on your own behalf at trial.
Yes, sir.
You understand that by pleading guilty, you'd be waiving your right to have the court order, you'd be waiving your right to remain silent, that silence cannot be used against you at any hearing or the trial in this matter.
Yes, sir.
And you understand that your plea of guilt will cause you to have 3 criminal convictions, all of which, 3 criminal convictions, all of which are felonies.
Yes, sir.
You understand that by accepting your plea of guilt, any appeal from the resulting conviction or sentence is by way of application for leave to appeal to the Court of Appeals, not as a matter of right.
Yes, sir.
All right. I don't know. Is there a request for a copy?
Yes, Judge, bottom third of the guidelines. Mr. Calora and I reached a preliminary understanding of guidelines in the area of 10 to 46 months. And so we're looking at the bottom third of the guidelines.
And we, of course, are objecting.
All right.
These are hand-to-hand deliveries, Judge. So
All right. I'll cap any time of incarceration to the bottom third of the guidelines. You understand that, sir?
Yes, sir.
Is that your full understanding of predisposition? So you're pleading to everything. The court has indicated that it would limit your exposure of incarceration to the bottom third of the guidelines.
Yes, sir.
All right. You still wish to go forward with this plea resolution?
you want to go forward with this plea resolution, do you not, sir?
Yes, sir.
Have there been any promises, threats, inducements, or coercion other than what's been stated on the record to your plea?
No, sir.
You're tendering your plea of your own free will and choice?
Yes, sir.
Tell the court what it is that you had done. We'll start with 18-1236-FH.
May I question you?
Yeah.
Oh, sorry.
Go ahead.
Were you in the city of Warren on March the 20th of this year?
Yes, sir.
And at that time, did you deliver cocaine to another person?
Yes, sir.
Right. And
Number 18-1237.
and on March the 22nd of this year, in the city of Warren, did you once again deliver cocaine to another person?
Yes, sir.
And then on 18-1238-FH, on March the 29th of this year in the city of Warren, did you, for a third time, deliver cocaine to another person?
Yes, sir.
Sir, you knew that was cocaine that you were delivering?
Yes, sir.
And have you previously been convicted of felon in possession of a firearm or
Yes, sir.
And were you also previously convicted of felony firearm on August 4, 2005 out of the Third Circuit Court of Miami?
Yes, sir.
And have you previously been convicted of possession less than 25 grams of controlled substance on January 13, 1993 out of Third Circuit in Miami?
Yes, sir.
The court satisfied, both parties satisfied?
Yes.
Yes, Judge.
The court satisfied that the defendant made a counselor and understanding. The court satisfied that the basis
Yes.
Yes, Judge.
And sir, as to the charges of 3 counts of possession, or I'm sorry, delivery, manufacturing, and less than 50 grams of a controlled substance, how is it that you wish to plead?
Give